All right, we'll call our special public council meeting for Wednesday, February 2nd to order. There's one item on our agenda. Can I get a motion to adopt the agenda, please?
So moved.
Move. Seconded?
Second.
Seconded. All in favor? Aye. Opposed? Carried. Correspondence, there's several, well, three correspondence. Some are quite lengthy from residents with concerns about the quarry. Those have all been circulated to all members of council and to the planning committee, and they're included in the planning report too, right? Okay. Alrighty. Committees of council. Planning, land use development. Deputy Mayor.
Okay. Our meeting was on January 18, 2022. Property address 45A Bawling Line, Backland Middle 3 Island Pond area.
Mayor, can you move your microphone closer? I can't hear you.
Okay,
Thank you.
all right. Now, can you hear me? Because I had a few residents that said last time.
Yeah, I can hear you now.
Okay, perfect. The background on this is the proposed quarry development, appeal board decision rendered on December 10, 2021. The background on December 10, 2021, the Eastern Newfoundland Regional Appeal Board ordered that the decision to deny final approval for the establishment and operation of a quarry at 45A Bawling Line made by the Council of the Town of Torbay on June 17, 2020, be reversed due to a flawed voting process. The Appeal Board ordered Council to undertake a renewed vote on the question of the conflict of interest for Mayor Scott and Councillor Appleby. This vote took place at the Public Council meeting of January 24, 2022, in accordance with Section 209-1 of the Municipalities Act. Mayor Scott and Councillor Appleby were voted not in conflict. The Appeal Board further ordered, once the matter of the conflict of interest has been voted on in accordance with the Act, that Council shall hold another vote on the request by the applicant for the final approval of his application. The Department is now tabling this application for renewed decision at the upcoming meeting as per the Appeal Board's order of December 10, 2021. Application process. Will I go down? I think I should go into that as well, okay. I might take a little while, but anyway, here it is. In the terms of due process, it shall be noted that in connection with this same application and a prior appeal of the original approval in principle issued, the Eastern Newfoundland Regional Appeal Board found that Council exercised its discretion in accordance with Regulation 90 pertaining to discretionary uses appropriately, but based on Supreme Court direction to add a condition to the approval in principle letter showing buffer and slope restriction requirements so that they can be assessed as part of the development review. Based on this discretion, Council unanimously voted to issue the revised approval in principle on May 17, 2018. Present, the conditions outlined in the approval in principle letter dated May 17, 2018 are what Council shall now review as Council considers a decision on the applicant's request for the issuance of a development permit. Torbay Development Regulations 2015 to 2025. Following are relevant excerpts from the Torbay Development Regulations 2015 to 2025 as they relate to the review of the file for development permit. Further, to having already considered the application in accordance with Regulation 90 pertaining to discretionary uses, Council has the authority to consider the application in accordance with Regulation 10, discretionary powers of council as well. Discretionary powers of council in considering an application for a permit or for approval in principle to carry out development, the council shall take into account the policy expressed with the municipal plan and any further scheme, plan, or regulation pursuant thereto, and shall assess the general appearance of the development of the area, the amenity of the surrounding available utilities, public safety and convenience, and any other considerations which are in opinion material notwithstanding the conformity of the application with the requirements of these regulations. The council may in its discretion and as a result of its consideration of the matter set out in this regulation conditionally approve or refuse the application. In addition, council shall be aware that in accordance with Regulation 21 Development Permit, the following requirements apply. Development permit. A written permit to develop, including a temporary permit to develop, issued by the council shall be permission to develop. This permission shall not relieve the applicant from all responsibility of obtaining all other approvals prior to the commencement of development and complying with the requirements of all other regulations and statutes during development. Number 2, the council may attach conditions to a permit to develop to ensure compliance with the municipal plan and these regulations, and the permit holder shall be responsible for full compliance and the permit conditions. Number 3, a permit to develop is valid for a period of 1 year and may be extended twice up to a total maximum period of 3 years. 4, the issuance of a permit to develop shall not prevent the council from requiring the correction of errors or ordering the cessation, removal of, or remedial work on any development being carried out that is in violation of the municipal plan and these regulations. 5, the council may revoke a permit to develop or for failure by the developer to comply with the municipal plan and these regulations, or any condition attached to the permit to develop, or where it was issued in error or was issued on the basis of incorrect information. Number 6, no person shall change the application for which a permit to develop has been issued unless the change has been approved by a resolution of the council and written approval has been issued. 7, a copy of the permit to develop and the plans and specifications shall be kept on the site until completion of the development. Recommendations of June 15, 17, 20 Public Council meeting. The following outlines the previous table recommendations for issuance of development permit as the conditions set out in the principal approval in principle letter dated May 17, 2018 has been met. So do you want me to go down over each of the?
During,
Those are the previous,
Yeah.
so you could just go back to the motions report and bring forth the motion for consideration by council tonight.
Okay,
Back up here.
yeah, that's where I'm to now.
Can I ask why
Yeah.
we don't have a question and answer period in the beginning, as
So-
was asked by a resident to have that
All right,
Yes.
done as we
so
would
then
normally
I go
meeting?
down here, committee's recommendation?
for a second.
Okay. In,
This, just 1 minute, the counselor actually asked a question. As is normal in our special public council meetings, we don't have a first Q&A.
Okay, so.
that's
we-
in the
that's-
middle of a motion, no?
No, you didn't read
Okay.
your motion yet. She just asked a question
Yeah, I'm
about.
just asking a question
Yeah.
because there is an email that we have that asks that there's
Right.
a question read out before a vote is taken.
Right, but I mean,
So
there's,
we've deliberately, again, not had a Q&A at the beginning of this meeting.
excuse me?
I'm just asking a question, we don't have it here.
We, for any of our special council meetings that we've had, we've only had a Q&A session at the end. This agenda's been up now for what, a couple of days? Yeah, so I mean, everybody should be
This
aware
agenda
of
went
that.
up last night. We've had 24 hours to review.
So just.
That's okay, I
to-
just want to ask the question,
If
that's
I
all.
could
Thanks.
clarify,
ahead,
the
Sally.
first Q&A session is an opportunity for residents to ask any questions on previous council meetings. The second Q&A is for business that's discussed at the current meeting. Hence, because this is a special public meeting, to deal with one matter only, there would only be the second Q&A. That has been our standard practice to do, how we deal with special public meetings.
Okay.
Thank you, I just wanted on the record.
Yeah.
Okay.
Thank you.
The committee recommendation, in accordance with the Torbay Development Regulations 2015-2025, the committee is tabling the following motion regarding proposal to develop property at 45A Bawling Line, Backland, in the middle of the Middle Three Island Pond Mineral Working Area for purpose of starting a quarry operation. May it be resolved that as the necessary conditions set out in the approval in principle dated May 17, 2018 have been met, that a development permit be granted in respect of the quarry application 45A Backland in the Middle Three Island Pond Mineral Working Area, subject to the following conditions. 1, development subject to meeting conditions outlined in approval in principle letter dated May 17, 2018 as attached. Number 2, development subject to engineering drawings labeled stormwater management existing Borough Pit Middle Tree Island Pond Road, Town of Torbay, Newfoundland and Labrador, prepared by May Design Limited. Drawing C-2 to C-5, project number 2019.114, revision 6, dated 03/06/20, and associated approval letters as attached. Number 3, in accordance with the Torbay Municipal Plan and Development Regulations 2015 to 2025, and the Torbay Mineral Working Regulations Revision 5 attached, clear delineation of tree buffer zones in the field by a surveyor licensed to practice in Newfoundland and Labrador is required. Inspection of said demarcation by Town of Torbay staff is required prior to any mineral working commencing. This is to ensure that anyone working in the field is aware of tree buffer zone boundaries. Number 4, prior to work commencing on the detention pond and feeder ditch, storm infrastructure shall be clearly demarked in the field by a surveyor licensed to practice in Newfoundland and Labrador and inspected by Town of Torbay staff. Tree buffer zones shall not be disturbed by activity associated with the construction of the detention pond and feeder ditch. Number 5, submission to Town of Torbay as built drawings signed by project engineer licensed to practice in Newfoundland and Labrador once detention pond and anti-silation ditches are completed. It is the developer's responsibility to inspect storm infrastructure, clean out silt ditches, and replace hay barriers as required. Inspections of the storm infrastructure shall occur on a biannual basis and before and after significant storm events. Copies of inspection reports are to be submitted to the Town of Torbay. Number 7, trucking and cutting and blasting shall occur in accordance with the provincial quarry permit number 14286 as issued by the Department of Natural Resources, Mineral Lands Division, and the Town of Torbay Mineral Working Regulations, Revision 5. In accordance with the Migratory Bird Convention Act, as per the Minerals Environment Assessment Release Letter of November 30, 2018, Reg number 1976, and Provincial Quarry Permit 14286, no cutting or blasting shall occur between April 15th and August 15th of each year. Number 9, standard permitting conditions of the town of Torbay. 10, annual fees and taxes in accordance with Torbay of schedule of rates and fees. Number 11, submission of copies of provincial quarry and cutting permits on an annual basis. Number 12, site mitigation shall occur in accordance with conditions as per Department of Natural Resources, Mineral Lands Division, as well as on a regular basis in accordance with Condition 17 of Torbay Mineral Working Regulations, Revision 5, and the RUR Land Use Zone Table, Condition C.J. This site shall be restored to not constitute a danger to the public and not be unsightly. The submission of a phase mitigation landscape plan shall be required for review and approval by the town of Torbay prior to closure of the quarry. Number 13, co-signature of conditional development permit by proponent. Number 14, copies of conditional development permit to be provided to Provincial Department of Municipal Affairs and Environment staff and Provincial Department of Natural Resources, Mineral Lands Division. So moved.
Second.
Okay, moved and seconded. Comments?
I just want to, I guess, really emphasize that with this application, it's been very difficult, I guess, and it's been on the go for a great period of time. And there's been many meetings that have been held since our notice of the decision by the appeal board. And the reason, once again, we're holding this meeting is to determine if the applicant has met the required conditions in his approval of principle is basically why we're having this meeting. So I really want to emphasize that. And that's it for me.
Okay, so we'll start our debate, I guess, with Councillor Goss, and we'll just go around and see how we'll time. 3 minutes. Councillor Goss, go ahead.
If it's okay, being newer councillor, I'd like to just hold off for a minute and just hear some other comments and feedback. Again, there's so much to take in for this actual decision here tonight, and any more information that I can take in before I actually make my vote, I'd appreciate. So would it be possible to go to Councillor Appleby and then circle back to me?
Sure.
Would that be okay?
Councillor Appleby?
Thank you, Worship. So, right out the gate, I'd like to note for public record that I've asked for a public motion to come before this motion tonight about council's action on this file. There is no decision, no public decision of council on the action that we were to take on the board's order. And the board's order said, according to section 46 of the Urban Rural Planning Act, the decisions for Regional Appeal Board can be appealed to Supreme Court. There has been no motion nor public decision made by the town of Torbay on the course of action on this file. And I sent an email to council and staff. I asked if there could be a motion before this motion came forward tonight so that the town could have an official decision and the public could see who voted for that official decision and action to be taken. It was ignored. There's an email here from Michael Duffy that he asked would be read out in the meeting at the beginning. And the questions were there to be asked if Ms. Schwartz had advised council in her professional capacity that a quarry could be complementary to and would not inhibit the permitted uses. And it also talks about asking each person who's voting for this tonight, when you're making your comments, to describe for the record at least one way that you believe the quarry will improve each of the adjacent conversational, recreational, and residential uses. We have sufficient and significant resident concern about this application. We have a situation we've spent over $150,000 on this single file of taxpayers' money. And I have to be honest, when I look at the questions that have been asked here, I do not know where conservational, recreational, or residential benefits would be realized by this development. At the end of the day, council is using its discretion this evening to make a decision. And I have looked at this, I have read everything about it, I attended the appeal board with Deputy Mayor Thorngoss, who spoke on behalf of who was invited, to speak on behalf of the developer. And at the end of the day, my understanding of this is not a project that is good for Torbay. It is not good for the residents of Torbay. And I have very significant concerns tonight when I hear that now all of a sudden there's 3 years that you can get an extension, when we went through this in June 2020, you could have 1 year extension after your 1 year was done. So I just want to make sure that the public understands the scope of what we're dealing with here. I am very sad to know that we aren't allowing the questions of the residents to come forward as requested. I'm very sad to know that the questions that I asked to be brought in public chamber were not done. And I'm very concerned about the impacts that any such quarry would have on the environment and the residents and the livelihoods of people in our community. So that's where I stand on this file. Thank you.
All right, thank you. Councillor Pollard.
Thank you, Your Worship. This is a difficult file, and of course, anything has been around for the number of years, and the amount of time and the number of appeals and the, I guess, confusion and I guess change in circumstance, really, that has been over time. I mean, you know, to Councillor Appleby's statements there about the letters, I think we all got the letters and we all seen the concerns expressed by residents. And we certainly thank the residents for, you know, all their input. And you know, I certainly have read, if not all, certainly the majority of them, and certainly the gist in all of them that I looked at is essentially the same. My concern rests with, you know, where we are today versus where we are back in time. And you know, my mind goes to, we are in a situation now where we continue to develop an area that was really rural. We have increased the number of houses in the area. We talk now of the traffic concerns. We even, you know, advocated to the provincial government to do something with the speeding and the imposition of speed humps and traffic controls on the, you know, on Balding Line. So we, you know, internally have already acknowledged that there are some issues there, and, you know, to add big trucks to that area may compound the issue overall. So, you know, there's concerns about the environment. The environment is, you know, a more in the forefront issue than has ever been. You know, as I said, years have passed. Go back 2018, you move ahead 5 years. There's way more environmental concerns now than there ever were. Time has passed, and I think the circumstances have passed. So I certainly feel that, you know, the original approval, and we were sent back to vote on it again. I think that, you know, looking backwards, we need to make a different decision here today.
All right, thank you. Councillor Manning, don't forget to turn on your microphone.
Thank you for the reminder. I too agree with what Councillor Powell and Councillor Appleby are referring to. It's difficult as a new person coming in, because in reality I'm in here halfway through a file. But also the reality is that I have an opportunity to voice my concerns. And this area, like, it's now has the residential tone to it, like 20 to 25 years ago, or compared to 20 to 25 years ago. Like, there's new homes, you got subdivisions, new families. To have an operation that will, no doubt in my mind, like, be so visual and disruptive in the sense of noise, extra heavy equipment, the possibility of fly rock, blasting with the homes in there, and you know, just the whole environment, the dust in the air, just going out in their backyard, and with the possible dust from, say, you know, the work that could possibly be done over there. But for me personally, it's the environment. It's taking away the look that's there. I go in there all summer long. I play ball. I drive past it. I look at that little mountain, or whatever anyone wants to call it. I have concerns with the buffer zone. Yeah, is it gonna be outside the boundaries? You know, the wetlands are really close. 15% sloping. Not knowing a whole lot about it, but, you know, is there a possibility of lack of control if the quarry goes ahead and, you know, that's not strictly adhered to, and I still have concerns over the approval in principle and the conditions being fully completed for the time frame. Those are gonna be my reasons and the grounds that I'm gonna stand on for when I take my vote. Thank you.
Thank you. Councillor Tapper?
Thank you, Mr. Mayor. I guess first of all, I want to thank everybody involved with this issue. It's been ongoing for even before I was started on council many years ago. But we're dealing with this now since, again, since 2016. I want to thank all the residents. They've sent many emails, as Councillor Appleby indicated. Many expressing their concerns. We did have some that supported the development for reasons one or the other. Council has had many meetings and discussions on this issue, many meetings. And we all also involved our legal advisor as well. The last couple of meetings, the majority of council did attend these meetings. Interestingly, I'll mention, interestingly, there's 3 members of our council who live on Ballyonline. It's a provincial road. And there have been many changes over the years, like many other neighborhoods in Torbay. We are the fastest growing, we were at least the fastest growing town for many years in this province. So things will continue to change. And there will be more developments occur in that area because there's massive amounts of acreage of land that is still undeveloped. So, you know, we got to look out for other changes. But, you know, as the committee chair indicated back in 2017, at the June 15th, 2020 public council meeting, in 2017, the town issued approval of principle. Then fast forward to June 15, 2020, public council meeting, it indicated, be it resolved that as the necessary conditions set out in the approval in principle dated May 17, 2019, have been met. I think that's the issue here. You know, council did go ahead with the approval in principle with a list of conditions. And the proponent, the applicant, set out and took some time, within a year, I think, or within the deadline anyway, and met all of these conditions. And they weren't cheap by any means to meet, because it was a long list of conditions. Some say is for this quarry application, the provincial government imposed far more conditions than any other quarry that ever exists in the province. So, you know, we did deal with the conflict of interest, and the appeal board ordered to hold another vote, and that's why we're here tonight.
Time, good.
So that's the end of it anyway.
All right, thank you.
Thank you.
Councillor Goss?
Thank you, Mr. Mayor. Thank you for letting me, I guess, take in a little bit more information on this topic. And I do see the pros and the cons of development and non-development. I do feel that times have changed, like Councillor Pollard had said, with when this first came upon, I guess, to council and the potential development of it. I just keep thinking about and looking about the residents in the area, you know, the safety, the property values. You know, I think about blasting and potentially affecting wells. I mean, it's all, maybe it may not happen, maybe it will. You know, it was more of a rural area at one point, now it's more residential. I know there's activity in the quarry there presently, but do we want more activity in the quarry there? So I just, looking at it from, I guess, a resident's perspective, I really feel that it's not something that I feel that it's something that probably wouldn't be on the top of my agenda if I was in the area. So at this particular juncture, I think it's not something I'm going to support.
All right, thank you. I'll just pass the chair to Deputy Mayor for,
Okay.
while I engage in this debate. I'll be quick. The issue for me that council is dealing with right now is that in 2017, council used its discretion at that time. And the appeal board upheld that and said that council used its discretion correctly, but sent it back to us to add additional conditions, which we did as council. We, 7 of us unanimously set out a new approval in principle letter to the applicant. To me, when I look at that, I have to feel that the word of the town means something. And regardless if it's a quarry, or if it's a subdivision, or if it's a single development, if a person comes to, and I guess I could put it in these terms, if a resident comes to the town and they're looking at purchasing a piece of land to build a house, and they come to us and we say, yes, you go ahead and purchase that, and they go and spend $100,000 on it to buy it and to do their work, and then when they come back to get their permit, and we say, no, we've changed our mind. I think for me, that's where I have my dilemma. You know, is the quarry good for our area or not? I can't say that it is. I just know that there's 3 there already. But to me, the part where council says to somebody, here's your approval, you can do this, provided you meet all these conditions. And they go away, so it could be a subdivision up on top of a hill, and they go and do their engineering and the roads and all that stuff and spend $1 million. And then come back and council says, no, we changed our mind, we're gonna put a park there now instead, we're not gonna allow that to go ahead. I think for me, that's the crux of the issue. We're not deciding on whether the quarry should go ahead or not. That was decided back in 2017, and the appeal board upheld that. What we're deciding on is, did the applicant meet his conditions? And the recommendation coming forward from committee and staff is that he did meet his conditions. So for me, that is the question that I have to ask myself. If the applicant met the conditions that were imposed on them by the town, then I feel I have no choice but to say, yes, you met your conditions, and here's your permit. So I think that, judging from a lot of the emails that came from residents, I don't know that they understand completely what process we're in right now. That the appeal board sent it back to us, we're bound by their decision to take a revote on basically the application as it stood back in whenever it was done last time, I guess 2019.
Time.
Okay, thank you. All right,
Okay.
go ahead.
All right. I guess for me, I'm looking at everything that's been said, and again, without getting in repeating everything, it was in 2017 that when the approval in principle was given. And again, as the mayor said, I feel morally that we gave this person, a developer, an approval in principle, and he worked on his merely way to make that happening, regardless of the financial burden that that's after putting on him. In that particular area, I know a couple of years ago, we looked at a 250 home development. Once that gets an approval in principle, we can't go back then and say, what about the traffic on the Balleen line or any other road? The town has no authority to say what can operate on any road, really, regardless if it's owned by the provincial government or for the town of Torbay. And when we tell somebody to meet those conditions and it's approved, then I feel, even though like I'm on the committee, But what the mayor is saying, we've given them our word that if you can meet those, and there were very difficult conditions to meet, that the intent was if you meet those, you come back, you have your permit. It's important to recognize that we don't come back. If a development was given approval in principle, it don't come back to the town to vote on again, regardless of what changes. And, you know, I'm hearing what people are saying, but if I built a new home in the area, I'd be checking out my surroundings to see if there was farmland or a quarry, like, it's something that's noticeable, and before people build in an area, they obviously knew what was in their backyard, and I remember saying this years ago. So again, I'm on the committee, and the recommendation is to approve, and, you know, and that's where I'm standing in there, knowing very well where everybody is coming from and listening to all of these. But to me, it's a decision that's morally,
Okay.
we gave our word on.
Okay, call the question.
Call the question.
All in favor? Aye. Opposed? Defeated. Thank you, everybody. We do have, so now our Q&A, and we'll be able to deal with some of these questions. And I tried to address the one that came in regarding discretion in my comments, and I do have some clarification on that. Yeah, okay. Deputy Mayor, whatever you were reading that time, can you forward that on to Ann to? Okay, all right.
The email everybody has.
Okay, all right.
Do you want me to send
No,
it,
that's
or Don,
fine.
do you want to send it?
That's fine, we have it.
Yeah,
Yes, you
yeah,
have it.
it's the one that was asked to be read here at the first
Yeah, okay.
Q&A.
Yeah,
Thanks.
no worries. So, I did get some, I did go back and ask for some clarification from the director. So the one was, has Ms. Schwartz advised council or professional capacity that a quarry would be complimentary and would not inhibit permitted uses? So, the recommendation is based on a past council already exercised its discretion in 2017. So that's where those questions come up, whether things are at the time when the application first came in. And at that time, council approved it in principle, and it was appealed. The appeal board said that council used its discretion correctly. However, they did send it back to get those additional conditions added to it. So that was that part. And secondly, we asked each of those choosing to vote in favor. Make your comments, please describe for the record at least one way you believe the quarry will improve each adjacent conservational, recreation, residential uses. So, I mean, council always expresses their opinion and their reasons for why they're gonna vote in favor or against something, and I think that, I think council did that. So, and there was an additional question that came in from Madeline Florent, and it has to do with the decisions around, I guess, Don, do you want to take this one and deal with it? See, there, I can't really answer this question because,
I can speak to that,
and you
Mayor.
can speak to that,
I'll do
okay.
that, yep. So there was an email received at 3:28 this afternoon from Madeline Florence, sent to the mayor and myself, and requested that it be read in its entirety at the Q&A this evening. So there's a three-part question afterwards. In 2017, despite strong public opposition dating back to the early 2000s, Council of the Day, by majority vote, reversed a long-held and legally upheld vision for the Middle Three Island Pond and Balleen areas of our town, which was that there would be no more new quarries in our town, that the Big Three Corner Pond wetland and its associated uplands would be protected, and that the whole area would be eventually rezoned conservation and turn into parkland for the residents of Torbay. This decision has been haunting council and the residents ever since. The impact of the 2017 reversal and the outcome of tonight's decision should be of concern to all residents of Torbay who live on or use our provincial roads, who enjoy the outdoors at Upper Three Corner Pond Park and Middle Three Island Pond, all on our ponds, on our trails, and to all residents who feel that when residents speak that loudly and for so long, they should be listened to by their elected officials. I have written many letters to council over the years opposing the quarry development, and I have participated in the appeal hearing since the beginning. My question tonight relates to the latest appeal board decision regarding the conflict of interest vote. To my knowledge, neither the province nor the regional appeal board have the authority to rule on conflict of interest, as these matters are settled by the Supreme Court. So Madeline's questions are: 1, was the appeal board's decision considered valid? 2, why did the town decide not to appeal this decision to the Supreme Court? And 3, who participated in making the decision not to appeal to the Supreme Court? And she said, I look forward to hearing answers to these questions during tonight's discussion. Madeline Florent. So Madeline, we received the appeal board report through our solicitors on December 14th, 2021. We did have a committee of the whole meeting on December 15th, and after that meeting was held, it was a budget meeting. We moved to a privileged session in which to enact client solicitor privilege. So anything that was discussed at that meeting would not come forward into the public chamber. We are mandated by the appeal board to enact the recommendations. There would only be a motion coming forth if council did not want to accept the appeal board's decision. Mayor Scott and Councillor Appleby were not at that meeting, and they would not have, even if they were at that meeting, they would have been asked to leave because there was particulars regarding a revote on their conflict. So neither Councillor Appleby or Mayor Scott were in attendance at that portion of the privilege session.
Don, just for clarification there, I was there,
Yes,
and I
but
had
you,
to
but you
declare my
let, but
conflict
yes,
and left,
yes,
right?
yes,
Okay.
correct, yeah. So in regards to the privilege session, I mean, legal decisions, discussions are not formalized, there's not minutes kept, and they're necessarily, legal does not need to take direction from a motion of council, that it was a discussion, it was consensus, and it was the consensus not to appeal the decision. So that answers your questions, Madeline.
Okay, all right, thank you. Alrighty, so that concludes our agenda for tonight. Our next public council meeting is scheduled to take place on Monday, February 7th, 2022, right here in council chambers in the town of Torbay. With that, I would entertain a motion to adjourn, please.
So moved.
Moved,
Second?
seconded, all in favor?
Aye.
Opposed, carried.